Good afternoon. Thank you for joining us today for a debate entitled, Can Natural Law Exist in the Absence of Religion? I want to give a sincere thank you to the John Templeton Foundation for their generous grant, and anyone enjoying the food today should be thanking them as well, I suppose. They are certainly very generous, and we want to recognize that. As you know by now, my name is Aman Sharma. I'm the president of the Moritz chapter, Federalist Society. On behalf of Brian Stewart, Thad Boggs, Dan Lautar, and everyone else on our board, I really want to thank you for coming out to our event today. We're expecting a pretty heavy crowd, and I know there's still a line for food, so as you get your stuff, please have a seat. Be patient, I guess. Thanks again for coming out. Our format today, as typical of debates, will allow for a 12-minute starting introduction by each speaker, again beginning with our guest speaker, which will be Professor Forte. That will be followed by a 10-minute rebuttal, and finally we'll field questions from the audience. Our speakers will take what your comments are. Today's debate will cover natural law. I know this is kind of a newish kind of concept, especially for the 1Ls. I did want to give a little bit of a quick Wikipedia type just introduction to it. Natural law is a topic that's been discussed at length by scholars in the Western tradition, from Cicero to Thomas Jefferson. Natural law is essentially the view that certain rights are inherent in or are universally and innately cognizable by virtue of human reason. I'll leave it to our speakers to give a more robust explanation. With that, I'll give an introduction of our speakers, and then we'll get started with Professor Forte. Daniel Tokaji, of course, I'll give an introduction for him. As most of you know him, he's a professor of law here at Ohio State. He's also the Associate Director of the Election Law at Moritz program. Professor Tokaji's areas of expertise include election law, civil rights, federal courts. His scholarship addresses questions of political equality, racial justice, and the role of the judiciary in democracy. He's a co-author of the casebook Election Law, Cases and Materials. Professor Tokaji's scholarship has appeared in Michigan Law Review, Stanford Law and Policy, and Yale Law Journal. He's the author of the Equal Vote blog, which provides commentary on election reform and voting rights issues. He's also the faculty advisor to the American Constitutional Society, our rival here at Moritz, but certainly a friendly rivalry with them. He's also active with the ACLU of Ohio and the Lawyers Committee on Civil Rights and the Conference of Asian Pacific American Law faculty. Prior to arriving at Moritz, Professor Tokaji was an attorney with the ACLU Foundation of Southern California from 1995 to 2003. He clerked for the Honorable Stephen Reinhardt of the U.S. Court of Appeals for the Ninth Circuit. He earned his JD from Yale, and he was the editor of the Yale Law Journal and a director of the Disability Law Clinic. He graduated summa cum laude from Harvard College in 1989 with an A.B. in English, American Literature, and Philosophy. Professor Forte is a professor of law at Cleveland State University, where he was the inaugural holder of the Charles R. Emmerich, Kathy Halter, and Griswold Endowed Chair. He holds degrees from Harvard College, Manchester University, the University of Toronto, and Columbia University. During the Reagan administration, Professor Forte served as chief counsel to the United States delegations to the United Nations and alternate delegate to the Security Council. He has authored a number of briefs before the United States Supreme Court and has frequently testified before the United States Congress and consulted with the Department of State on human rights and international affairs. He served as consultant to the Pontifical Council for the Family under Pope John Paul II and Pope Benedict XVI. In 2003, Professor Forte was a distinguished Fulbright chair at the University of Trento and returned there in 2004 as a visiting professor. For the academic year 2008-2009, Professor Forte was a senior visiting scholar at the Center for the Study of Religion and the Constitution in the Witherspoon Institute in Princeton, New Jersey. Professor Forte was a Bradley Scholar at the Heritage Foundation and visiting scholar at the Liberty Fund. He writes and speaks nationally on topics of constitutional law, religious liberty, Islamic law, the rights of families, and international affairs. He's a senior editor of the Heritage Guide to the Constitution, published by Reggie Green Company, and a clause-by-clause analysis of the Constitution of the United States. Please join me in welcoming Professor Forte.
Good morning, afternoon. All right. Now, as a descriptive matter, natural law comes from God. But we don't need to, here's the neat thing, we don't need to know that to understand natural law. As a descriptive matter, natural law leads to God. But here's the neat thing, we can accept natural law without having to travel that path. So let us begin at the beginning and do a little exegesis. The religious creation stories of every culture are a window to their idea of what the nature of God is and what the nature of man is. And it's from the religion's creation stories of the Judeo-Christian tradition that we have the source of why the natural law theories of the Greeks and Romans fit so comfortably into the Christian tradition. Now, the Lord God in Genesis 2 had formed out of the ground all the beasts of the field and all the birds of the air. He brought them to the man to see what he would name them. And whatever the man called each living creature, that was its name. So the man gave names to all the livestock, the birds of the air, and all the beasts of the field. What's so significant about that? In the creation of Jewish and Christian tradition, God separates nature from himself. He gives man reason and discernment, and then allows man to discern the order of nature. In other words, he gives man his freedom, and with it the capacity to discern the truth. Let's look at another part of this saga. God made the wild animals according to their kinds, the livestock according to their kinds, and all the creatures that move along the ground according to their kinds. And God saw that it was good. Let's stop here for a moment. God made the animals according to their kinds. In other words, according to their natures. And God saw that it was good. It was objectively good that things have their own natures, separate from God. God did not just create things that have their separate natures from him, but that it was good, objectively so, that he did that. Why is it good that things have their own natures? Because God himself has his own nature, and is subject and logically limited by that very nature. Such things are, as Aristotle would have put it, goods in themselves. Nature of anything is another way of saying it is true to itself. And so it is that man has reason, and throughout Western history, humans have applied reason to discern the order of the material universe. They have had the God-given effrontery to apply their reason, even to try to understand the nature of God. We call that theology. And they have applied their reason to discern the moral order of human life. What have humans found in the material and moral order of existence is what we call natural law. That's all it is. It's the intrinsic order in the material and moral world. In each case, whether scientifically or philosophically, we seek the truth. So now let's begin with a working definition of natural law, since it's not really taught in law schools these days, Natural Law 101, so that we can have an appropriate understanding of what we're speaking of. Why is natural law natural? Why is natural law law? Well, nature is the reason why something is the way it is. For example, we can discover and define what the nature of a manatee is, and by that determine and define why it is different from other water animals. Laws are rules of behavior, some predictive, as in the phases of the moon, and some subject to voluntary actions, as in moral laws or moral rules of behavior. As humans, we are subject to both forms of natural law. My heart beats to a predictable pattern, but I can choose to lie, or I can choose to follow the moral rule of truth-telling. We normally use the phrase natural laws to refer to the patterns of behavior of material bodies and animals. Natural law, on the other hand, is normally reserved for the moral rules of behavior deriving from from the nature of man. The rules apply to each individual in his or her relationship to others and to himself. Now, there are many traditions of natural law. That is, there are many descriptions of what the nature of things are and what the moral nature of the human person is. Some are Aristotelian, Stoic, Thomistic, Neo-Scholastic, Grotian, Kantian, phenomenological. Natural law has boomed as a philosophy since the 1970s. There's more been written on natural law in the last 3 or 4 decades than any time since St. Thomas Aquinas. Natural law in its modern phase focuses on the nature of the human person and attempts to discern what are objective goods for the human person. What are goods in themselves, not mere instrumental goods. Instrumental goods are, I eat in order to get sustenance. I study law in order to pass the bar and get work. Goods in themselves are goods that are purely good in themselves. We apprehend that they're good in themselves, even if they have no other instrumental value. So, for example, these immutable goods, or irreducible goods, I should say, are such as life. Existence is a good in itself. It's not an instrument, it's something else. It's something to be treasured in and of itself. Now, there are others. Let me get to the others, but I tell my students in my course, Theories of Justice, when they say, what are all these philosophers talking about? And I say 2 things. There are 2 questions philosophers ask themselves over the centuries, and this is the conversation they're in. Number 1, what's real? They call that ontology. And number 2, how do we know it's real? They call that epistemology. So how do the natural lawyers say you arrive at the conclusion that something is good in itself? You arrive at through 2 processes. One is experience, just as Aristotle was saying, and 2, a rational reflection on that experience. So we experience life, and if we rationally reflect on it, we come to the conclusion that it's an irreducible good in itself. To be is a good. Knowledge. You know, so much of our knowledge is instrumental. But sometimes, you know, you're just curious about something. If you're just curious about something, it's not instrumental. You just want to know it for the sake of knowing. Have you ever been in a class or in some instance or conversation where something just clicks in your mind? You say, I got it. What have you got? You experienced the moment of knowledge. This awakening, it's a good in itself. It doesn't have to be instrumental. So, these goods, what are they? Knowledge. Think of play. Play is a good in itself. I mean, there's so much play that we do so that we can get in shape. But just look at 4 men on a golf course. They love the play of it. Play is a good in itself. Aesthetics. Something is beautiful simply to look at.